Good evening, ladies and gentlemen, and welcome to Courtroom Conversation. I am your host Trishita, and today we will revisit a landmark case, Tehseen Poonawala vs. Union of India, a bold stand against mob lynching. What did the Supreme Court say? How India's new criminal laws replacing the old IPC and CRPC. Let's address this dark reality. In 2018, India was rocked by mob violence in the name of cow protection, religion, or WhatsApp rumors. Activist Tehseen Poonawala moved the Supreme Court demanding state accountability. The Supreme Court called it mob lynching, mobocracy, saying it threat to the rule of law. In today's show, Ms. Shinjini Bose is joining us. She is a legal expert and constitutional commentator. Welcome.
Thank you so much for having me. It was a historic judgment. As the court said, mob lynching is not just a criminal act, but also a constitutional failure. Article 14, right to equality before law. Article 15, prohibits discrimination. Article 21, right to life and dignity. It invoked Article 32, allowing citizens approach and court when these rights are violated. According to the nodal officers, to fast-track courts to victim compensation, the court laid down all preventive and remedial measures.
So now let's talk about the legal gap. Under the Indian Penal Code, there was no specific law for mob-specific lynching. Such cases were loosely tried under Section 302 murder, Section 147, 148, 149 rioting and unlawful assembly, Section 34 common intention. None of these laws define lynching as a separate crime.
Exactly. The law treated a mob like it would a group of individuals, ignoring the collective psychology and organized hate behind lynching.
India has a new criminal framework now. The IPC is gone. Enter the Bharatiya Nyaya Sanhita 2023. So what's new?
For the first time, under Section 1032 of BNS, if a mob 5 or more persons cause death on grounds like race, caste, community, sex, language or personal belief, the punishment is life imprisonment or death penalty.
To recap, mob defined under 103, under old IPC it was not defined perfectly, but under new IPC it's clearly defined.
This shows real progress. The new incorporates the spirit of the Supreme Court's directions in the Poonawala case. But laws are only as strong as their enforcement. We need strict implementation, public awareness and accountability from local police and admin.
Tehseen Poonawala's judgment was a judicial warning. The Bharatiya Nyaya Sanhita is the legislative response. That's all for today on Courtroom Conversation. Keep asking questions, keep seeking justice. I am Trishita signing off. Good night and Jai Hind. Thank you for being in the program, Ms. Shinjini.
Thank you so much for having me.